Welcome to Supreme Law. We update regular videos to improve your knowledge. Don't forget to like and subscribe to my channel. The Act lays down the procedure for the admission and exclusion of evidence, the burden of proof, and the evaluation of evidence in a trial. The Act recognizes two types of evidence, oral and documentary. Oral evidence includes all statements made by witnesses in court, while documentary evidence includes all documents, records, and other written or printed materials. Under the Act, evidence must be relevant to the matter in dispute to be admissible. This means that the evidence must have a direct or indirect connection to the facts that are in question in the case. Irrelevant evidence is not admissible. The Act also lays down the rules for the admissibility of hearsay evidence. Hearsay evidence is a statement made by a person who is not present in court and is being offered to prove the truth of the matter stated. In general, hearsay evidence is not admissible, but there are several exceptions to this rule. The Act also provides for the burden of proof in a case. The burden of proof is the obligation of a party to prove the facts that are in dispute. In a criminal case, the burden of proof is on the prosecution, while in a civil case, the burden of proof is on the party who has brought the case to court. In conclusion, the Indian Evidence Act is a crucial piece of legislation that provides the framework for the admissibility, relevance, and evaluation of evidence in Indian courts. Its provisions ensure that the evidence presented in court is reliable and credible, thereby ensuring that justice is served. Here are some references to the sections in the Indian Evidence Act that deal with oral and documentary evidence. Section 59, Proof of Facts by Oral Evidence. Section 60, Oral evidence must be direct. Section 61, Proof of contents of documents by oral evidence. Section 62, Primary evidence. Section 63, Secondary evidence. Section 64, Proof of documents by primary evidence. Section 65, Proof of documents by secondary evidence. Section 66, Rules as to notice to produce. Section 3, Interpretation Clause. Section 2, Definitions. Section 17, Admission of a party to the proceeding. Section 35, Relevancy of entry and public record made in performance of duty. Section 61, Proof of contents of documents by oral evidence. Section 63, Secondary evidence. Section 64, Proof of documents by primary evidence. Section 65, Proof of documents by secondary evidence. Section 67, Proof of signature and handwriting of person alleged to have signed or written the document. Section 68, Proof of execution of document required by law to be attested. Section 69, Proof of document not required by law to be attested. Section 74, Public documents. Section 76, Certified copies of public documents. Section 78, Presumption as to genuineness of certified copies. Section 79, Presumption as to documents produced as record of evidence.